Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode will be somewhat different from our normal format. Rather than taking a look at police interactions directly, today we are going beyond the body cam footage to explore the legal nuance that unfolds after a police encounter, inside the courtroom. This channel has dedicated years to educating members of the public about how to properly navigate police encounters, but interactions with law enforcement rarely end once the body camera is turned off. And possessing a thorough understanding of how to navigate the courtroom is equally as important. In this episode, we will take a look at two different courtroom interactions that give some insight into how judicial proceedings work, and fill in important context when relevant. This episode will serve as a trial run for this format, so be sure to let us know if you enjoy post-encounter related content in the comments below. Our first courtroom encounter occurred on December 3rd, 2024 in the Harris County Criminal Court in Houston, Texas. The footage shows Judge David Fleischer presiding over an arraignment and probable cause hearing for defendant Trevor Flores, who was charged with unlawfully carrying a firearm in a vehicle. An arraignment is typically the first formal step in the criminal process following an arrest. During this proceeding, the defendant is informed of the charges filed against them and advised of their constitutional rights. The judge also asks the defendant to enter a plea, usually guilty, not guilty, or no contest, and determines whether the defendant will be released on bond or held in custody. Now, in conjunction with the arraignment, Judge Fleischer also held a probable cause hearing. This type of hearing is intended to evaluate whether there is enough evidence to justify the defendant's continued detention and proceed with the prosecution. Unlike a trial, the standard at a probable cause hearing is not proof beyond a reasonable doubt, but whether there is a reasonable basis to believe that a crime has been committed and that the defendant committed it. Now, because Mr. Flores had already been taken into custody, the court was required to make this preliminary determination before moving forward. Probable cause hearings are especially critical when questions arise about the legality of the arrest itself, as was the case here, given that the traffic stop leading to Mr. Flores' arrest raised jurisdictional concerns.
Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had marijuana inside. The defendant admitted he did have marijuana inside, as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana under the passenger seat.
Got it. All right, Mr. Flores, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license? Do you not?
I have a SR22 in place. My license was suspended.
Okay. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit with me today, promising you that you're not going to drive. Do you have liability insurance in your name? Car insurance?
Yes, sir.
Okay. I don't want you driving until you have a Texas driver license. You need to call DPS, figure out what to do to get your license. I'm going to give you the phone number now, but it's time for you to get your license back. And when you show me that you have your license and that you have car insurance, I will happily allow you to drive. But until that point, do not drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is a condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir. So I'm not allowed to retrieve my weapon back?
I'm ordering you now, while this case is open, not to have any weapons.
Yes, sir.
Okay. Here, Stephen, do you mind giving this to me, please? This is the number to the driver's license division to DPS. You need to call them in the morning to figure out what you need to do to get your license back. Give them your license number and ask them what you need to do to get your license back.
Okay.
Once you do, I'll tell you, I'll take this off, you know?
Yes, sir.
Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to fill out an application for me. I'll take a look at it. And then assuming you qualify, I'll give you a lawyer today. I'm going to have you sign this agreement with me today that you're not going to drive. And I want you to understand, Mr. Flores, I take this so serious. Don't drive. If you drove here, you can't drive home.
No, I didn't drive here. My father did.
All right, so I'll have you come up here, swear to us. May I have you go to Jemay, sign a reset, and then we'll have you fill out the application, okay?
Okay.
All right.
Judge Fleischer informs Mr. Flores that because his license is suspended, he is not allowed to drive until he gets his license reinstated, even though he has a so-called SR-22 in place. An SR-22 is a financial responsibility insurance certificate that an auto insurer files with the Texas Department of Public Safety, or DPS. Texas law requires drivers who have had their driving privileges suspended for violations such as driving while intoxicated, drug offenses, driving with an invalid license, and multiple convictions for driving without car insurance to file an SR-22 with DPS in order to reinstate or maintain their driving privileges. However, the certificate itself does not lift a license suspension or grant driving privileges while a suspension is in effect. A motorist whose license is suspended must first satisfy all reinstatement requirements, such as paying fees, completing any mandated programs, and waiting out the suspension period before the SR-22 enables the license to be reinstated. As Judge Fleischer explains, because Mr. Flores' license was suspended, he was not lawfully permitted to drive, even though he had obtained SR-22, and doing so could lead to further penalties.
Bringing a shared code book at the moment. We may have to have you look at a couple interesting things.
Okay.
And this is on the Trevor Flores case, Judge, and I think you visited with that gentleman earlier. He's present here in the courtroom at the moment.
Okay.
But I got the case this morning. I've had a chance to do a kind of little bit of digging
Cursory.
into. Yes. And although we are still waiting for the bulk of discovery in the case, he's charged with unlawful carrying of a weapon following a traffic stop. And I've got a map that is kind of intriguing. I think you'll find just with the way it's drawn. But he stopped by an officer with the City of Bel Air Police Department. And may I approach to just show you this delineation? But he's pulled over going.
I know the area well.
Northbound. He's pulled over going northbound on 610 as what is described as makes an unsafe lane change. So he's northbound on 610, wants to get on 59 to go southbound, is erroneously in the wrong lane going northbound. The officer says that she has observed him, makes that unsafe lane change, and that lane change is outside of the City of Bel Air Police Department jurisdiction. Now, we have a particular statute that governs whether officers can have the authority to make a detention of someone when they are outside of their jurisdiction, and that's 14.03 of
Their
their.
PD can still stop someone outside of Bel Air.
Not for, well, according to the code, it says a peace officer.
That would mean that any officer outside would never be able to do anything.
No, that's incorrect. There's a very limited exception, and that's what applies in this case. So it says a peace officer who's licensed and is outside of the officer's jurisdiction may arrest without a warrant a person who commits any offense within the officer's presence or view, other than a violation of subtitle C, Title VII of the Transportation Code. So generally, any offense that an officer sees, he can arrest that person or detain them, as the way the code uses that term, arrest. He can detain that person. But when it's for a traffic offense, that officer is
It's not
required.
arresting him for a traffic offense, though.
Well, that was the basis for the stop.
Sure.
And but the way the code contemplates arrest, it's any, and that's defined in, I think, in chapter 15. But arrest, as contemplated by the code, includes detention. And so this officer doesn't have the ability, where that stop takes place, to make that detention. That officer could detain him if he saw him committing theft, could detain him if he saw him committing an assault, can't for a transportation
So,
code
but
violation.
he stops him for whatever reason it is, right? Comes up to the car and he smells marijuana,
Yes.
right?
Well,
And
that's
then
what-
don't they even get a drug sniffing dog? Is this the one where they get a drug sniffing dog and they find the weed and,
No, Your Honor, that's it.
was that a different case?
No, it's a different case, Judge, but the handgun, I believe, was in.
It was in plain view.
No, I think so I think what's alleged is it's in conjunction with possession of marijuana. And for purposes of just this limited PC question, my focus is solely the detention. I'm not.
It's certainly crafty. It's great. But he's not arresting him for the traffic offense.
Well, But I think we're looking at a limited scope of what arrest means. So I think you're looking at arrest as in
So
being
you
arrested.
would be saying that really if he had committed an ag rob, right? Or
Well,
kidnapping, then even if he had kidnapped, like let's say he had a 2-year-old child in the car that he had kidnapped across state lines. Well, then according to this, because he's in a different jurisdiction, then you couldn't arrest him on that kidnapping charge
If
too.
he saw a kidnapping taking place, the officer could arrest him under that code. But what he can't do is when there's a traffic code violation, we don't allow for example, the El Paso Police Department to come to Houston and then sit on the street corner and arrest people for traffic violations. We don't allow them to make those stops. And that's what's at issue here is a peace officer who's outside of his jurisdiction able to enforce the traffic
I
code.
know where you're going and I've seen it before, but I'm not.
And we're looking at G1.
Where exactly did it occur anyways?
Let me see if I can pull up the
So I
exact
think-
address. We don't have like any discovery in
Sure.
this case or have any dash cam or anything like that.
So what it says in there is 5600, 610 northbound. And what's so curious about this is.
That's still in Bel Air? Is it
No,
outside of
that
Bel
would be
Air?
outside of Bel Air too. And going northbound, southbound lanes are covered in the city of Bel Air. The northbound lanes, for some reason, are not.
I don't know. We'd have to look closer. I don't know.
Yeah, I'm
mean,
happy to
it's
look
something
further
that
into this.
You have to
Judge.
look. I mean,
can't make
I
any-
can't make that determination now.
Fair enough.
Number two,
Yes.
he's not arresting him on a traffic offense.
Well, and I think what the code contemplates when it says arrest, and I think there's case law on this, is that it includes the concept of detention as that's been, because I think when that code was written.
And so what I'm saying would apply as well, though. Like if he catches a 2-year-old kid, right, that's been kidnapped, by your theory, he wouldn't be able to arrest him on the kidnapping charge too.
Well, it's not my theory, it's the code.
If he has a dead body in the car, he wouldn't be able to do it.
Well, that's a legislature question. And I mean, but they wrote that.
I can't imagine that the legislature intended that. I think that they intended for a traffic, let's say for speeding, right? Or your tail light is out. Yeah, not to arrest in that respect. But he goes up to the car, smells marijuana, sees a gun in plain view. I can't imagine the legislature intended in that purpose.
And my position, of course, is that, this may be for a motion to suppress later down the line, and I think there's still
But
plenty more to do in the
it's a
case.
freaking awesome argument.
But the idea
I love you.
is
Mr. Wonderful.
no right to
Right?
detain him.
Right? Really?
I appreciate the judge, and we'll get it.
I'm not ready yet, but build it. If you build it, they will come. And then we'll take a look down the road and yeah.
Thank you, Judge.
Attorney Brian William Lee Garris was appointed to represent Mr. Flores and argued that the arrest was unlawful on the grounds that the officer who initiated the traffic stop was acting outside his jurisdiction. To support his claim, Mr. Garris cited Article 14.03 of the Texas Code of Criminal Procedure, which generally prohibits officers from making warrantless arrests for traffic violations when outside their jurisdiction. Judge Fleischer pushed back, stating that Mr. Flores was arrested not for a traffic offense, but for a weapons charge. In response, Mr. Garris pointed to the definition of arrest within Article 14.03, arguing that it includes not only custodial arrests, but also detentions, such as traffic stops. He referenced the 2004 Texas Court of Criminal Appeals decision in State versus Kurtz, in which the court determined that a traffic stop qualifies as a quote-unquote arrest under Article 14.03. However, Mr. Garris based his legal position on Section G1 of Article 14.03, which permits certain peace officers, specifically those listed in subdivisions 1, 2, and 5 of Article 2.12, to make warrantless arrests outside their jurisdiction for any offense committed in their presence, except for violations under the Transportation Code. The key issue with Mr. Garris's argument lies in the classification of the officer who stopped Mr. Flores. The officer was a member of the Bel Air Police Department, which is a municipal agency. Officers employed by incorporated municipalities fall under subdivision 3 of Article 2.12, not 1, 2, or 5. Therefore, Section G2, not G G1 governs their authority outside city limits. According to Section G2, a municipal officer may make a traffic-related arrest outside their jurisdiction if the offense occurs within the county where their municipality is located. Now, since Bel Air is situated in Harris County, and Mr. Flores was stopped within that same county, it appears the officer's actions likely fell within the legal bounds established by Article 14.03. According to Harris County Court records, the charge against Mr. Flores was dismissed on March 4th, 2025, after he completed a so-called alternative resolution agreement that required him to attend a gun safety class, reinstate his driver's license, and forfeit his weapon. Our next courtroom interaction took place on March 18th, 2025 in the Allegan County 57th District Court in Michigan. This recording captured Attorney Magistrate Daniel Norbeck conducting a Zoom hearing regarding a traffic citation that Deputy Dylan Kibbe of the Allegan County Sheriff's Office issued to 21-year-old Josh Webb.
This is for too fast for conditions as well as failure to yield to emergency vehicle. These are civil infractions, Mr. Webb. You have a choice of what to do on them. You can, 1, admit responsibility to a citation, or 2, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or 3, you wish to contest the citation, in other words, to fight a ticket at what we call informal hearing. What were you looking to do?
I would like to contest this ticket.
Both?
Both
Moving
of them.
violations? Yes. All right. Then, even though I cannot see you, I'd ask you to raise your right hand, same way the deputy's going to raise his right hand. You swear or affirm any testimony that you'd give here today would be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
All right. Mr. Webb, it makes a lot more sense for me to start with the deputy. He has the burden to establish to me why you were issued these citations in the first place. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf. All right?
Okay.
And with that, Deputy, you want to pick up the narrative somewhere it makes sense? Explain the issuing of this citation.
Conducting routine patrol in Watson Township. I was traveling westbound on 116th Avenue. I observed the defendant's vehicle driving directly ahead of me. While driving behind that vehicle, I paced it at 58 miles per hour for approximately 3 miles. Upon activation of my emergency lights, the vehicle continued driving for approximately a quarter mile before turning left onto 19th Street and coming to a stop. At that point, I made contact with the defendant, explained the reason of the stop, and issued the citation.
All right, Mr. Webb, what is it you wish to tell me?
I guess I'll just tell my story. I was on my way back from school because I forgot that it was spring break. When I got onto 222, I saw Mr. Kibbe sitting in like the little construction area across from the gas station. That's when I decided to flip him off. This obviously made Mr. Kibbe upset, prompting him to pull out behind me and begin following me for a few miles until I reached a downslope. I had my cruise control set at 57. So as soon as I hit the bottom of that downslope, my car accelerated a little bit, supposedly 1 mile an hour. And this is when Mr. Kibbe turned on his lights, and it was very obvious that he was targeting me. So I instantly, right away, started slowing down and decided that turning off to the left was going to be my best case scenario because it was going to put Officer Kibbe out of the main road, which I know is one of the leading causes of death for officers.
Deputy, what is the speed limit on this road?
55 miles per hour.
All right. So the too fast for conditions is the 58?
Correct.
And failure to yield to emergency vehicle is the driving for a quarter mile before you pulled over?
Correct. Your Honor, my understanding of the failing to yield for an emergency vehicle moving is that they have to pull immediately to the parallel to the road they're currently on. And in the event that I was heading to an emergency, he would have been impeding me by turning left across both lanes where I couldn't pass him.
Okay. Gentlemen, Mr. Webb, you know how dumb it is to needlessly upset law enforcement, right?
Yes, I know that.
Because they have certain powers that they can exercise over your life and make your life difficult. It was a dumb thing to do.
Yes, and I have
All right.
stopped since then.
All right. Here's the problem. Violation of basic speed law, too fast for conditions, is essentially, that's the wrong citation. You could have wrote him a citation for 1 to 5 over, and that's what he'd be looking at. But the violation of basic speed law is essentially when you have a slide off or something like that, you were going too fast for conditions. And that having the accident is the prima facie evidence that you should have been driving slower to sort of, avoid that happening, as opposed to just essentially a speeding ticket, meaning nothing happened with your vehicle, but a moving violation that you were in fact going faster than posted speed limit. So this could have been a faster than posted speed limit ticket, but the way it's written, a violation of basic speed law, we reserve that for a failure to maintain to your vehicle to stop a clear and assured distance before you hit something else or before you leave the roadway. The other problem is the failure to yield to emergency vehicle is this. Once an officer is trying to pull you over and it's obvious to you or reasonable to an objective person that the officer is trying to pull them over, i.e. lights and sirens, and there's nobody else but you, then you know that they're trying to pull you over. The issue with that is you do have the right to. Now, I'll tell you right now, if you just speed up and drive away, this turns very quickly into what's called fleeing and eluding, which is a felony crime, right? But if the officer's trying to pull you over, you are able to drive to a place that you feel is more conducive to a safe stop. A lot of time what that means is, oh, it was late at night, it's a country road in the middle of nowhere, and I know there's a gas station, a quarter mile up the road, so I, put my blinkers on, or I drove 35 miles an hour, but I drove all the way to the gas station because I'd rather have this interaction take place in the lighted parking lot, or something like what Mr. Webb is explaining, that, 222 is a lot busier than, say, pulling off to a lesser used road. So provided the fact that you only went a quarter mile is the sort of saving grace here, and that you did pull over. But the way that you explained it, there is what I would say a grace period there for pulling over, as long as what you're doing is pulling over to what you consider to be a safer, either for you or for the officer. The way you articulated it, really, you articulated it for the officer, but it's allowed to be for your safety. But that is not necessarily what this statute, failure to yield to emergency vehicle, is written for. I wouldn't find either of these two actions to be violations of the statutes that you were written for. But like I said, gentlemen, it's pretty clear here, Mr. Webb, what you did. You used really bad judgment that normally is going to end up costing you money, right? And costing you points on your driver's license, because it's just a dumb thing to do. Don't do it again.
Okay.
All right. But I would not find you responsible on these citations as they're written. We're all set with this today, gentlemen. So
all right, thank you.
Go our separate ways and think twice about how we carry ourselves in the world. All right.
Yes, sir.
Thank you, Your Honor.
Magistrate Norbeck ultimately dismissed the charges against Mr. Webb, finding that he did not commit the alleged offenses of failing to yield to an emergency vehicle and violating Michigan's so-called basic speed law. The charge for failure to yield was based on Section 257.653 of the Michigan compiled laws, which requires drivers to yield to emergency vehicles exhibiting both a red or blue light and an audible signal, such as a siren. The law states that upon the immediate approach of such a vehicle, the driver must pull over to the right-hand edge or curb, come to a complete stop, and remain stopped until the emergency vehicle has passed, unless otherwise directed by a police officer. However, the statute is clearly intended to govern situations in which emergency vehicles are responding to active emergencies and attempting to pass through traffic, not when officers are conducting routine traffic stops. Now, in this case, Deputy Kibbe testified that he had activated his emergency lights, but he gave no indication that he had also activated his siren. Because the statute requires both visual and audible signals to apply, Magistrate Norbeck found that the stop did not meet the legal criteria under Section 257.653. A more appropriate statute for evaluating the traffic stop would be Section 257.602A of the Michigan compiled laws. This section makes it unlawful for a driver to willfully disobey a lawful signal to stop, whether that signal comes by hand, voice, emergency light, or siren from a police officer acting in the course of their duties. However, the key element of this offense is willful failure to comply. As Magistrate Norbeck explained, Mr. Webb continued driving only a short distance to reach a safer location before stopping, and did not exhibit any intent to flee or evade. Therefore, the statute did not apply. Now, regarding the speeding charge, prosecutors relied on Section 257.627, commonly referred to as the basic speed law. The statute requires drivers to operate their vehicles at a quote-unquote careful and prudent speed based on road conditions, and also prohibits traveling at a speed that would prevent the driver from stopping within the quote-unquote assured clear distance ahead. According to the Michigan Judicial Institute's traffic bench book, the quote-unquote careful and prudent clause is based on the standard of ordinary care, essentially the speed that a reasonable person would consider appropriate under the circumstances. Meanwhile, the so-called assured clear distance rule is typically applied in accident cases, where a collision is used as evidence that a driver failed to maintain proper stopping distance. Well, in this case, there was no collision, and Mr. Webb was allegedly driving just 3 miles per hour over the posted speed limit. Magistrate Norbeck found that this did not rise to the level of a violation under the statute, and dismissed the charge as legally unsupported. It's also worth noting that even if Deputy Kibbe initiated the stop because Mr. Webb flipped him off, the Supreme Court has repeatedly ruled that an officer's subjective motivations are irrelevant to the legality of a traffic stop. In the 1996 case of Wren versus United States, the court held that a stop is lawful under the Fourth Amendment so long as the officer has probable cause to believe that a traffic violation occurred, regardless of intent. And in the 2019 case of Nieves versus Bartlett, the court further held that the existence of probable cause generally defeats a First Amendment retaliatory arrest claim. Finally, in the 2018 case of District of Columbia versus Westby, the Supreme Court clarified that probable cause to arrest is based on an objective standard. If there is probable cause for any offense, the arrest is lawful, even if the officer cites a different or incorrect offense at the time. So, even though Deputy Kibbe may have cited the wrong statute, the stop would still be considered lawful if he had probable cause to believe that Mr. Webb was speeding. However, marginally taken together, these legal standards suggest that while the citations may not hold up in court, they were likely valid enough to defeat any constitutional claims of retaliation. As mentioned before, this episode is a test for this type of content, and there is an unlimited supply of courtroom interactions available for analysis if you enjoyed this format, so be sure to let us know your thoughts in the comments. If you have any suggestions for how these episodes could be improved, feel free to share that in the comments as well. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.